Good morning, everyone. We'll call the meeting of the DuPage County Development Committee of January 6th to order, and then we have a roll call.
Member Krajewski?
Here.
Member Martinez?
Here.
Member Covert?
Here.
Member Ozog?
Here.
Vice Chair Yu? Chair Tornatori?
Here. Chairman's remarks, just to wish everyone a happy new year. Glad everyone's back. We have public comment this morning. For those of you who are here to public comment is limited to 30 minutes, 3 minutes per person. We take no new evidence. No new evidence will be used, but you're certainly have the opportunity to comment on anything that's on the agenda. I would simply ask that if you have something to say that's been said previous to what you can say, you can just say you agree with it or you disagree with it. Make life a lot easier and quicker so everyone has the opportunity to speak. We'll begin with Glenn Nelson, who is here. I'm not sure which item, but Glen Ellenswood subdivision. So Glenn, wherever you're at.
Yeah, okay.
Yeah.
Okay. I'm here regarding the 7-Eleven location on Park Boulevard, the 7-Eleven location on Lloyd Avenue, and the Penny's Place location on Butterfield. I attended each of the zoning board of appeals meetings, and I submitted written opposition letters to those committees on each of those locations. I did not see those in the agenda minutes. So yesterday or the day before, I sent a letter to members of the board. I think, Mary, you're the only one on this board that received it. With the same letter, but one of the more comprehensive ones I've written, which is for the Butterfield mobile location. But and you should have that. It's representative of all the other ones that were sent. But in general, it explains all the reasons for opposition to video gaming in these facilities, including the ordinance violations that are applicable at every single location, except for a couple that are on the agenda today. So I'm just reiterating that opposition.
And I know I received it, but I think we all received.
Oh,
what
you
you
did?
said, so.
Okay. All right. Thank you.
Thank you. Brian Armstrong.
Hi, good morning again, everybody. My name is Brian Armstrong. I represent the applicants. I'm actually going to speak on two different agenda items, 6E, which is SMM management, and I'll start with that. The other one will be 6G, which is Lucky 7. For 6E SMM, as you know, the zoning board of appeals recommended approval of the relief that was requested. This is a variation for a gaming facility. It's at a very busy intersection in Downers Grove. A couple of important points that I just want to highlight. There are some other gaming facilities within 1,000 feet, but this particular facility was licensed before all of those other gaming facilities that are within 1,000 feet, and was also licensed before the county imposed the 1,000-foot separation requirement for gaming facilities. So it has been operating continuously since 2001. Licensed both by the county and by the state since 2001. As I'm sure you know, the county's 1,000-foot separation ordinance came into play in 2004. So they've been operating for several years before that. There is a church that is property line to property line is 918 feet, and door to door is over 1,000 feet. The important thing to know about that is there are large roads between the church and the facility. So it's not like kids are going to be easily walking by and have the chance to walk into the facility because of that. And churchgoers are the same situation. They're not going to be walking by and just casually walk in. As I said, the zoning board of appeals found that the applicant's evidence did meet the standards to approve the variation for these reasons. It would be a hardship for the variation to be denied because, as I said, they've been in business operating for 3 years, long before the other facilities and long before the separation ordinance. This facility would close if it's not allowed to continue to operate by variation. So for those reasons, I respectfully request that this committee approve recommendation to the county board. Moving on to 6G, which is Lucky 7 Bistro in Addison. Again, the zoning board of appeals, based on the evidence presented, recommended approval of the requested relief. And this is again a variation, and this is because there are other facilities within 1,000 feet of the proposed facility. Now, this facility, they applied for their building permits for the gaming facility and started construction on the interior in 2023, more than a year before the county imposed the 1,000-foot separation requirement. So in reliance on the existing ordinance at that time, they expended over $250,000 in getting to this point. The other gaming facility, there are other gaming facilities within the village of Addison in the area, and this area of the county is kind of an island of unincorporated, surrounded on all four sides by village of Addison property. And the village of Addison has no separation requirement at all, let alone 1,000-foot separation requirement. So there are several gaming facilities within the village of Addison, within the municipality. There's American Tap across the street. There's Lacey's down the street. There's Millie's Pancake House. But again, those are all in village of Addison. And I think that informs why the variation is appropriate here. That there's kind of a historical reason for the 1,000-foot separation, which is not having too many vice type uses close to one another. The fact that the village of Addison has no such separation requirement is very good evidence that the reasoning for the separation doesn't apply in this particular location and shouldn't be applied to this applicant here. There is a liquor store in the same strip mall as well that my understanding has applied for gaming. At the time Lucky 7, the applicant here is requesting relief. At the time they applied for their permit and started to undertake their work, that gaming facility in the same strip mall had not been approved and was not operating. So that shouldn't be a reason why Lucky 7, who's now 9/10 through the process and a lot of money through the process, that shouldn't be a reason why they would be denied. That would be a hardship. Again, for these reasons, these are some of the highlights of the reasons why the Zoning Board of Appeals found that the variation was appropriate, why the evidence met the standard for the variation. So again, I request that the committee recommend approval to the board. Thank you.
Thank you. Jonathan, I can't figure out what the last name is, but for 7-Eleven.
Jonathan Lipner.
Which of the 7-Elevens are you here to talk about?
All three of them, so that's items
Okay.
6B, 6D, and 6E.
Okay.
So good morning, my name is Jonathan Lipner, and we just mentioned I represent 7-Eleven. First, I just want to give a quick background on the situation that the stores are in. They have been operating video gaming since around 2022 and 2023 with all the required approvals that have been granted by the Illinois Gaming Board and the county. They have received the liquor licenses. And roughly in around April 2024, the county informed these stores that they would not renew their licenses because of the violations of the county code. The county subsequently amended their ordinances in 2025 and issued the new Class G2 liquor licenses, and all three 7-Eleven locations, they operated with these approvals beginning in 2024, and then these were recently approved again this past year, beginning in July of 2025. In 2025, that was the first time the county has raised the instant 1,000-foot distance requirements that are at issue here. And I presented testimony at the prior hearings that 7-Eleven justifiably relied on these license approvals. Now, I would like to go over the decision of the zoning board back in December. And there are a number of errors that I'd like to point out for the committee that, and in turn, they should recommend to the county board that these petitions should be approved. Standards for either a zoning variation or conditional use are found in section 1411.3 or 1413.5 respectively. I'm not going to read them through, but they are similar. The zoning board determined that there was an inadequate showing of hardship or practical difficulty. I'd just like to make note that there is no mention of those terms in the standards. Additionally, these 7-Eleven locations are no different than the stores that received the approval from the zoning board. All these stores, they operate no more than 6 video gaming terminals in compliance with the rules of the Illinois Gaming Board, and 7-Eleven would suffer the same hardships that were found that the zoning board determined to be present. They've all put in resources to install these video gaming terminals in no dispute are still in effect. They are operational. Someone has put resources into them. They would suffer a business detriment if the approvals are not provided to them. And I would like to discuss the code that,
Your time is pretty close, so.
okay, so 7-Eleven did meet the standards. Just my last point is these stores, they've been present and in operation well before video gaming was legalized in Illinois. There's no physical structures that are viewable from outside of the building, so there's no effect on the nearby neighborhood, the adjacent boundaries, no effect on traffic, fire hazards, or the water systems in the area. So 7-Eleven does meet the standards, and there's been no objection from the other departments in the county. So I recommend that this committee should recommend approval to the county board. Thank you.
Thank you. Mike Gibson?
Yes, yes, sir. Thank you. I'm in for 005. We are the petty place on Butterfield. I'd like to point out obviously for the board to deny or to not recommend that we are denied the variance. We've been open for 44 months in operations. There's been 2 zoning changes. Not only would this create an undue hardship on us, it will create an undue hardship on the 15 employees that we have there. Our landlord, as it will be an empty space, and the fact that there's been a change in the rules since this has happened. As we went through the zoning board, there was no ask us to prove that any of the items that we were supposed to prove up were to be addressed. There's been no issue with flooding. There's been no issue with lighting. In the 44 months, there's been no issue with any of the items. We did not know that we needed to prove a negative. If that's a fault on us, we apologize for that. But considering that we had a building and zoning inspection of June of 2025, and none of those items were mentioned after this rule had already been put into place, we were unaware of the fact that we needed to prove that our operations had met code because we had been continued to get licenses for the last 4 years, including this most recent year of June of 2025. We have 14 locations in DuPage County. We pay over $1 million a year in rent to our various landlords, and we have generated over $4.5 million of video gaming tax between the other people. So this change will be detrimental to us. It'll be detrimental to our employees. It'll be detrimental to our landlord. So we would ask that you either let us reapply if we do need to prove that up, or that you ask that we would be existing non-compliant because of the rule changes recently, and we will meet those rule changes moving forward. Thank you.
Thank you, Mike. Lastly, Greg.
Yo. Good morning, everyone. I'm the president of our civic association for the Glen Ellen Woods. Within my neighborhood, there's 6, count them, 6 gambling locations. Within a quarter of a mile, there's 4. That's a lot. This board, or even the county, doesn't even know of 2 of them because they haven't come up in front of the variance, have been every variance. Board meetings, this is the first development meeting. So that being said, I oppose all this going on. I know everyone's claiming hardship due to, if you don't get it, they're going to go under. I don't care where you live. I have 6 within a mile and a quarter from my house. We don't need them in DuPage County. The casino's down the road in Aurora. All these are just basically little mini casinos that everyone's using, and they are grabbing the people's money. That being said, all it's doing is creating more issues with our communities. People losing money, can't afford bills, relying more on our communities to support these people. We don't need this. If you want to open a casino, open a casino. We don't need these little mini casinos in our neighborhoods. And on some instances, there are schools within 65 feet of these places, daycares. There's a school within 300 feet that's in one of these places that was never mentioned in anywhere. We brought it up. It's like, let's look at this portion, but let's not look at the whole big picture. So what is the big picture for DuPage County? I don't want to see all these casinos all over the place. If you put one, everyone's gonna open them. They're gonna open them and then beg for variance later. And that's what it's becoming. Let's open it. Oh, we're doing good business. Look, we have no complaints. But it's still, let's beg for the variance because there's a daycare next door or there's a school within 300 feet. Oh, we're not bothering them, but you are. In our big community, it is. And I would not like to see this move forward. So please oppose all of them.
Thank you. And that concludes the public comment portion of the meeting. We'll move on to the minutes. I'll entertain a motion to approve the minutes of November 18th. Last year.
Second.
Any additions, corrections, or deletions? Hearing none, seeing none, all those in favor?
Aye.
Any opposed? The minutes are approved. Moving on to item 6A, regulatory. Entertain a motion to approve 26-0155, a recommendation for approval of a contract to Ventex LLC doing business as Atkinson Baker, a Veritex company, to provide court reporting services as needed for the building and zoning for a period of December 24th, 2025 through December 23rd, 2026 for contract total not to exceed $24,213.75.
So moved. Second.
Any questions, comments on this? All those in favor?
Aye.
Any opposed? The motion carries. Entertain a motion to approve DCO 1-26 zoning 2542 711 Park Boulevard. Zoning Board of Appeals recommendation to deny conditional use to allow a video gaming terminal establishment in a B1 local business zoning district. The variation to allow a video gaming terminal establishment within 1,000 feet of a place of assembly, and a variation to allow a video gaming terminal establishment within 1,000 feet of an existing video gaming cafe, restaurant, video gaming terminal establishment. This is generally located southeast of Butterfield Road and Park Boulevard. As the members of the committee are aware, we take all our motions in the affirmative, even though there was a denial here. Do I have a motion to approve this?
So moved.
Or second?
Right.
Or a second?
Oh,
I made a motion.
sorry.
Motion, second.
Can we ask?
No, hold on. Is there a motion?
I did the
Is there a
motion,
second?
original motion.
Second and Mary. Okay, there's a motion and a second. All right, now we'll have comments or questions regarding this. Member Martinez.
I would appreciate some background on all of them
Okay. we're gonna get that.
together because I don't understand why some are being approved or recommended for approval or denial, even though they all look similar in terms of.
Okay, Paul, you want to give a little background on generally the ordinance, where we're at today, maybe where we were,
In 2000,
similarities being similar but not the same.
in 2019, the county board approved video gaming. There were no regulations in place when video gaming was approved by the county board. There are no zoning regulations. So the default requirement to have video gaming in the unincorporated area came from the state of Illinois. There was one provision in the state of Illinois' regulations dealing with local governments, and that was in order to meet all of the state requirements, you had to at the very least get a liquor license from your local community to pour liquor at the establishment. And that's what brought the county into the regulatory aspect of getting video gaming facilities in the county. All of the video gaming facilities that you've heard today received a liquor license to pour, and that then allowed them to get their gaming license from the state of Illinois. However, they never received any zoning approval because these facilities were existing, for the most part, existing facilities, C-stores in the case of 7-Elevens. And so all they needed to do was get a liquor license from the county in order to get their gaming license from the state. So they never went through the zoning process. In 2023, we recognized that there were several facilities in the county that had video gaming, but were not in compliance with the local zoning regulations. So we endeavored to create regulations in the zoning code and the liquor control ordinance that would address some of these concerns. The county board approved a change to the zoning code back in 2024 and the liquor control code. The liquor control code allows for establishments that have packaged liquor licenses to also have pour liquor licenses, where prior to 2024, you couldn't have both a pour and packaged liquor license in your facility. The new liquor control code does allow you to have both a pour and packaged liquor license in order to be able to have video gaming in some of these facilities. The zoning code was changed to allow for video gaming cafes as a separate standalone facility, and also video gaming devices within an existing facility, like a C-store, or like a gas station, or a banquet facility, by right in a B2, I1, or I2 zoning district, and by conditional use in a B1 zoning district. In addition, the county set standards that any facility that had a gaming cafe, standalone gaming cafe, or video gaming devices had to be at least 1,000 feet away from protected uses and other video gaming establishments. The 1,000-foot distance requirements for protected uses were for schools, daycare centers, and religious institutions. That language essentially comes from the same regulations that we have for cannabis facilities, which is a newly adopted ordinance, and also for other what are considered vice type uses, such as adult business uses. In 2024, when these gaming facilities that had previously been given liquor licenses that allowed them to get their gaming licenses, they were given the ability to, they applied for their liquor licenses and also their gaming licenses, and they were denied in zoning for the reasons of they were not in the correct zoning district. They were in the B1 zoning district, which required conditional use, or they were also either in a B2 zoning district, but too close to the protected use of schools, daycares, or places of assembly. And so the folks that are here before you today have applied for zoning relief. And the Zoning Board of Appeals is obligated to review the standards for zoning relief against the current zoning code, which is you've got to be in a B2 zoning district or get a conditional use by B1, and you have to be 1,000 feet from protected uses. The Zoning Board of Appeals can't consider previous licenses that were given by other departments. They have to consider the regulations relative to the existing code, which is adopted in 2024. And that's what brings us here today.
And then can you explain why 6E and 6G are being allowed?
So without getting into the minutia, I can get into the minutia in each individual case, but the Zoning Board of Appeals found generally that in the cases that were approved, the petitioner established zoning criteria for hardship, practical difficulty, or unique circumstance that were land use related. In the other cases, and you heard some testimony today here, it's not new testimony, incidentally, it was discussed at the Zoning Board of Appeals meeting, that the applicants submitted more of a hardship relative to financial concerns, which is not a hardship that the Zoning Board of Appeals can consider. It's not a land use consideration. In addition, you heard that some people had argued that they should be grandfathered in. The Zoning Board of Appeals can't consider that. They can only consider land use arguments, hardship, practical difficulty, or unique circumstances related to the land, as opposed
Can
to.
you give an example?
So in the two cases that were recommended for approval by the Zoning Board of Appeals, the petitioner had demonstrated that the 1,000-foot distance requirement is a standard that the county has established that is very well established in case law as a way to protect vulnerable populations, folks who would be located at a school, a daycare, or a religious institution, from the secondary attendant impacts that might come from the use, from the vice type use. The petitioner was able to show that even though in some instances, the ones that were approved, that their properties were closer than 1,000 feet to a daycare center, a school, or a religious institution, the actual buildings were more than 1,000 feet. In addition, the petitioner was able to show that there were other mitigating circumstances rather than just distance that would protect vulnerable populations for many perceived or actual secondary impacts. For instance, there's a daycare center within 1,000 feet of one of the facilities that was approved. But the petition was able to show that that daycare center was for kids that were 6 years old or younger. So none of the kids would be walking around or even passing by the video game facility. And in addition, the petitioner was able to show that building to building, a church was more than 1,000 feet away from their use. And also that there were what are called collector roadways, heavily traveled roadways that carry over 25,000 movements a day that were between the location of the video game facility and these protected uses. So that the petitioner was able to show the zoning board of appeals that there were other mitigating circumstances that would cause the video gaming facility not to have a detrimental impact on protected uses that were beyond the 1,000-foot distance requirements that's in the zoning orders. The other video game facilities did not prove up those types of land use arguments. Their arguments were financially based, or they argue that they should be grandfathered in because they had received licensure and video gaming licensure and liquor license from the county, irrespective that at the time, those uses still didn't meet the zoning ordinance.
Okay, other questions for other members of the board?
Just want to clarify when we vote on this in the affirmative, just so everybody knows, if we're upholding the zoning board of appeals, we vote yes to uphold it and no to not uphold it. Is that, did I get it?
The motion's in the affirmative, so if you vote yes, then you are approving the petition. And if it is denied at the zoning board of appeals, you will be reversing that decision. Correct. Vice Chair.
Yes, thank you, Chair. I have a procedural question. So there was some testimony that said that they were not able to provide some kind of testimony or evidence that had to do with each of the different categories that the zoning board of appeals was looking at. And Paul just mentioned that a lot of their arguments was based on financial hardship that really didn't count, and it wasn't on land use arguments. And so I'm just wondering if do they have an opportunity to have another bite at the apple later, if they were to come back and then present those actual specific points?
My understanding that they can withdraw their petitions. Be withdrawn from today's discussion, and we could send it back to CBA.
There's a couple of things.
Or a new petition could be filed.
Yes, there's a couple of things that would certainly be up to the petitioner. One of the concerns that this body would have and the ZBA would have is that there is a public record already established. So if this were to be remanded back to the zoning board of appeals at the request of the petitioner, that public record would still be in place. Another option is the petitioner can simply withdraw and refile and create a whole new public record.
And then present whatever evidence in their case, whatever manner they wish to that time.
And I just ask one more question. So with regard to 6B for the 7-Eleven Park Boulevard, I think it says in the documentation that it's 903 feet from a church. Is that right, Paul? I'm just trying to ascertain the distance with regard to how far from a church, how far from a school, because that was really the thrust of why we have this county ordinance and why we passed it and why we specifically did it for 1,000 feet. So that's what I'm really looking at to see is how far each location is from each of these protected places.
So for Park Boulevard, which is at the corner of Park and southeast corner of Park and Butterfield Road, it is approximately 401 feet from Glenbard South High School to the northwest, and that's property line to property line. And 571 feet property line to property line from St. Barnabas Church, which is directly to the east of the property. Do you want me to go through all of them?
Yes.
Relative to the 7-Eleven 6C on Maple and Belmont, 100 feet property line to property line to the Belmont Bible Church to the north, and to the daycare center, which is in a strip shopping center to the south, 75 feet, property line to property line. Relative to the 6D 7-Eleven on Lloyd and Butterfield Road, it is 66 feet away to the west to a daycare center and a school. Relative to 6E, SM Management, which is northeast corner of Belmont and Maple. It is approximately property line to property line, 80 feet to the strip shopping center to the southwest, where the daycare center is, and 660 feet to the Belmont Bible Church to the north. 6F, which is Penny's Place, which is,
Sorry,
I'm sorry.
Jared, is that okay? Just quick
Why
question.
why don't you finish the.
6F, which is the Penny's Place, which is at the southwest corner of Butterfield and Park. 386 feet, property line to property line to St. Barnabas Church to the east, 463 feet, property line to property line, Glenbard South High School to the northwest. And then 6G, which is Lucky 7 Bistro, 250 feet from an existing video gaming facility in the village in Addison.
Okay,
I do have a follow-up question with regard to 6E. So I know that from public comment from attorney Brian Armstrong, he had stated that it was 918 feet from a church and door to door over 1,000 feet. That is different from what you just stated for 6E.
So from building to building, it's 1,010 feet from the building which houses the video gaming, which could house the video gaming facility, to the building on Belmont Bible Church. So to 1,010 feet beyond the 1,000-foot distance requirement.
So it is over 1,000 feet.
Building to building. Our code says property line to property line. So property line to property line within 1,000 feet, building to building, more than 1,000 feet. And the petitioner's testimony at public hearing, and then here again today, was that the children that will be in the Belmont Bible Church are in the building. There's no playground. They're not in the parking lot. So that was the argument that supported his testimony that the use would be mitigated because they are over 1,000 feet building to building.
For
Where the
that
kids would be
one,
located.
well, we're not gonna jump, let's take this one at a time. We'll be recognized by the chair. Are you done?
Yes, thank you.
Okay, anybody else who has not commented yet? Let's just take the committee members first. Brian. We'll get to you, Tom.
Just, I guess, in general, and then the comment on this particular one we're talking about. First, I think, was it 2010 when video gaming, state of Illinois is the one that legalized video gaming. And I think the county was very late in 2019, where many municipalities approved video gaming. Especially down in my district, you got, Westmont and Woodbridge and Daring and Lombard, a lot of them have it. And so a lot of the establishments are coming to the county saying they were right across the street from villages. Now, in villages, it appears that, at least down in my district, there's a lot of them that didn't have the pouring of liquor. Where did that come in, that liquor license of having a pouring?
The state of Illinois requires, the state of Illinois requires a pour license from the local jurisdiction.
So does that apply to villages too?
Should applies to villages too.
So they just have it, but they don't have it.
Well, the only place where it is not required is if you are a truck terminal. You're not required to have a pour license at a truck terminal.
Okay, so some of these places that don't have,
Might
they have
do
a
a truck
pour
terminal.
license, but they're not pouring. Okay. And so 2019 is when we came in. So then to get to the specific one, I'm reading the
Which specific one? are
the
you
one where you
referring
just made the motion on, the 7-Eleven
Okay, all right.
on Butterfield. So, I mean, I read the VBA general and everything. It says they did not demonstrate and then they demonstrated. So I didn't have time to go back. I just pulled up one of them here for the 7-Eleven, which I understand, we'll get to these next. The one on Belmont, there's two of them. One was a yes, one was a no. But Mr. Lipner, at least on the Belmont 7-Eleven, made a good argument. He hit the criterias here. I assume he did the same thing for this Butterfield one, but I don't know. I don't know what the transcript says. I have to read it. But didn't he reference the stormwater, the flooding, the light, did he reference those in that one?
He did, but
But the zoning board,
he didn't
said-
reference the hardship, practical difficulty, or unique circumstance issues.
but you need that for each, and you need a hardship practicality for each individual criteria for stormwater. Because it says in our minute or in our agenda item that they did not demonstrate a flare, they did not demonstrate the property values going down, they did not demonstrate, that's all it says. But when I go in here and I'm reading at least the other 7-Eleven one, it appears that he referenced those and made a good argument. That, and I got the one across the street that's actually gonna be approved, we'll get to those when we get to those two later. I just haven't read that, but it sounds like he did reference those in the hearing versus somebody just testified today that we didn't approve, or we didn't mention any of those. Had we known, we maybe have done it and maybe go back and do that. But in this one, I assume that they made the same argument for the other 7-Eleven, the one we're currently have the motion and a second on.
So two things. Whenever we have a zoning case, irrespective of what it is, we always send a letter out to the applicant saying, your case is going to be on this date. And these are the things that you need to prove up, whether it's rezoning, conditional use, or variation. We make it very specific to the case at hand, what they need to prove up and show at the zoning board of appeals. The zoning board of appeals found that the petitioners where the cases were denied didn't prove up hardship, practical difficulty, or unique circumstance. There, in addition to that, is another test that talks about things that you're talking about. How would this use have an impact on adjacent roadways, congestion in the streets, stormwater, light, air to the adjacent properties? That's the second test that one has to prove up in any zoning case. But the primary test is, what is the practical difficulty, hardship, or unique circumstance with the land?
But when I'm reading this in here, it tells me they did not demonstrate those other ones.
Well,
And when I'm reading this transcript for this particular one, it appears they did.
and the zoning board of appeals found that the petitioner, when they testified to those sort of secondary things, they just essentially said, it's not going to have an impact on light or air, on traffic, on adjacent properties of diminution of value. They didn't necessarily say why. So that's the reason why the zoning board of appeals said they may have commented on it, but they didn't say, here's why it won't have an impact on the diminution of value, traffic, light and air, and so on and so forth.
And if I get in and read the one on this 7-Eleven, the one across the street, when I get to that one that actually did, they're gonna say, they're gonna touch on those in more detail than this one?
Yes. Yeah, that's what the ZBA found, yes.
Well, I know that's what they found. It doesn't, we've reversed the ZBA multiple times.
Understood.
Because we read something that looks like it's a hardship and then ZBA did. So, without me going in depth on that, I go, but I saw a good argument here for me. I assume he made the same one on the 7-Eleven we're currently talking about.
Right.
And the ZBA just decided against it. Okay.
Remember to start, you had a question.
Thank you. Are all of these before us today? Because did these businesses all exist? And did they exist as gaming businesses? And then the county changed the rules?
Not all of the businesses existed with video gaming facilities.
Okay.
For instance, the 7-Elevens were existing C-stores. And then they got ancillary to the convenience store, they got to video gaming. In the case of
They were around.
in the case of
That one's here since
in
2001.
the case of SMM, that was an existing Angelo's food market that had ancillary to it, the video gaming.
So that's been there since 2001,
The
as testimony.
so video gaming in DuPage County wasn't approved until 2019. I think there was a mistake in terms of when video gaming was allowed. It was allowed in DuPage County in 2019. I think the attorney said something about 2004. It was actually 2019 when video gaming was allowed. In the case of SMM, that was Angelo's food store. They had ancillary to Angelo's food store meat market. They had video gaming devices. In the cases of the 7-Elevens, those were going concern 7-Elevens for many, many years, probably back into the 70s. They just added to those 7-Elevens the ancillary use of the 6 gaming devices. In the case of Penny's, Penny's is a standalone video gaming cafe. That was not in operation before 2019. In the case of Lucky 7 Bistro, that was not a going concern. It's still not a going concern. It's a brand new facility. But, so 2 facilities, or I'm sorry, 4 facilities were existing C-stores or meat markets. Penny's was a standalone.
So the gaming piece is what's new.
Gaming piece is what's new as of, in some instances, 2019, moving forward. No gaming before 2019 in unincorporated DuPage.
So what you're saying is that all these businesses have installed gaming devices without checking with the county.
All of the businesses that have video gaming licenses checked with the county under the state statute, which said, go get a local liquor license. So they all went to the liquor control office, got their liquor license to pour. Once they got that, they were able to get their video gaming devices from the state. Those facilities, however, didn't check with zoning or apply for a permit for zoning. If they had, they would have been in design and zoning and presumably not been able to receive their liquor licenses. Just as an example, some of the board members may recall that we have had people that have come in and asked for what are called Class B restaurant and had to get parking variations. And the whole reason and those were denied. And the whole reason for trying to get those Class B restaurants and parking variations was to start up a video gaming store. Because the only way under the zoning code prior to 2024 to get a pour liquor license was to be a Class B restaurant or a tavern. And you may recall that some of those people were coming in the auspices of being a restaurant, when in fact they were just going to be a gaming facility. But that was the only thing available to them at the time under the zoning.
Thank you. Thank you, Chair.
All right, Member Martinez, I'm sorry, Member Ozak has a question.
Paul, you might be able to help with this, and I've done a perfunctory look on the internets. What is the gambling age? Because I'm seeing 21 to enter casinos, 21 online, but it's 18 to purchase lottery tickets. So where did I'm not really.
21.
Okay, it is 21 to use a video machine.
21 relative to the video gaming devices that we're talking about here today.
Okay,
That's one of the reasons, for instance, the state requires you to get a liquor license because the vetting process to get a liquor license is very stringent. And the idea, it may sound counterintuitive that in order to video gaming, you have to also be able to drink. But the idea of getting a liquor license from the local jurisdiction is that you have to go through that very stringent process. You've got to go through several departments to get that. You have to get fingerprints, a background check.
pay your fee.
And pay the fees, yes.
So the assumption is that the 21 limit would be respected by these, I mean.
In addition to that, there are, under the state gaming license, there are requirements that the areas that are, where you have mixed use, where you have a C-store and then you have video gaming devices.
That it's separate.
That they're separated. And there are inspections that are done by the state gaming board. There's a lot of requirements at the state level. The only prior to 2024 at the county level was you get a liquor license. But there are many requirements at the state level that you have to follow.
Any idea if video surveillance is required?
Yes.
It is, okay, thank you.
In addition, the state has an allowance of not more than 6 video gaming devices in the majority of uses. It can go up to, I believe, 10 in truck stops and some of the social clubs like the DFW and American Legion, things like that. But for the ones that we're talking about here, it's maxed out at not more than 6.
Member Martinez.
Just really quickly, on 6E, you mentioned something about 80 feet, but it didn't catch what that was for.
I'm sorry, will you repeat your question?
6E, you said it was, I wrote down 80 feet, but I don't know, I didn't write down what 80 feet was for. Daycare. A daycare. Was
So,
it 80
yeah,
feet?
it's from property line to property line. So we measure, at that point, the right of way is 80 feet wide. So it's from property line to property, not building to building. If you were to take building to building, as the petitioner testified and said today, to the Belmont Bible Church, they're more than 1,000 feet. And from the actual daycare facility, from building of the video gaming facility to the daycare, which is on the far west side of the strip shopping center. It's about 611 feet from building.
So
to
it
building.
doesn't, either way, the daycare is not within 1,000 feet, whether it's property line or building to building.
The daycare is within 1,000.
Right. It is.
Both
within-
property line and building to building.
Both.
The Belmont Bible Church is within 1,000 feet, property line to property line, but beyond 1,000 feet, building to building.
Chair, I have to chair my technology committee and, I gave 5 more minutes to the crowd outside. Are we
Why don't
making
they
comments
propose?
right now? I don't know if I'm gonna have time to, I want to be here to vote on all of these, but I don't know if I'm gonna have enough time if we're gonna. If you want us to comment, do you want me to comment on like in general, just like everybody else is right now and then leave?
Well, I think
Or-
we're commenting on the issue before us, which is item 6B. So, I mean, if you have a general comment you want to make,
Yeah,
Go ahead.
yes, I would, but, I would. My general comment, just, hearing the arguments, today about these facilities, I'm assuming these are restaurants, most of them are restaurants, and I've heard,
no,
arguments.
they're not. They're not.
Is 16 not a restaurant?
They're not restaurants. There's convenience stores,
Bistro,
some are,
Lucky 7 Bistro, is that not a
It's
restaurant?
no.
Lucky 7B, under our new code, 2024, we created 2 categories for video gaming. The gaming cafe and video gaming devices within an existing facility. The bistro is actually considered a gaming cafe.
Okay,
They
so
don't
there's no
necess-
food or
They don't
anything.
necessarily have to serve food. In the past, and I apologize if I'm complicating things. In the past, as I said earlier, the only way you could get a pour license was to be a restaurant. You don't have to be a restaurant. You could be a standalone cafe, just serve alcohol and game.
Yeah, I'm just seeing a lot of these facilities within the 1,000 feet of the daycares or churches. And about the grandfathering, and if we grandfather these places in, then we have to grandfather other people in for other issues on this board. Like, you know, I don't agree with the whole grandfathering in these facilities. They're close by a daycare, they're close to churches, there are children that pass by. I mean, I've heard the argument that kids won't come out of the daycare and pass by these gaming facilities. That's not true. Daycare teachers take children out for walks, and if they can't take them out because of the gaming facility, then they're just gonna be bound within their daycare, never being able to go out. I have kids, you know, Montessori school, they kick them out. The hardship argument, if the facility is entirely dependent on this, I mean, there's other places where they've you know, they have done well without just a particular gaming facility or gaming device. We have programs here at Choose DuPage and, you know, through the county to help businesses, and they do have an opportunity to come back with a new petition. So I guess my comment is I'm just not fully convinced by the arguments that were made today. And it's just dangerously close to daycares and churches, and I would not be in favor of this.
Just one point of clarification, relative to grandfathering. As it relates to zoning, it's our contention that there is no grandfathering or legal nonconforming opportunities here because these were never approved in zoning. So there's no grandfathering opportunity. If there was the opportunity to appeal the decision, and we don't have any appeals on these cases because there's no grandfathering allowance here.
But the ordinance changed after they went in business, but we still have to comply with the new ordinances that are passed in our county. That's my only comment. And then I will have to leave.
okay. You still have a quorum. Yes, I'm Rosa.
So, getting back to your last statement, if these pass or don't pass today, that would then be grounds for an appeal to the zoning board of appeals.
No,
No?
no, we're a recommending body.
That's next week.
We recommend to the county board. The County board makes the ultimate decision on whether or not these petitions will pass or not pass,
Right.
just like every other.
But
thing
could they
that comes
come
before.
back with a completely fresh slate? And then use this as a springboard?
So 2 things. To appeal a
Just to
zoning.
make things more
Yeah, to
complicated.
appeal a zoning decision of staff, under our requirements under the state statute, you have to appeal within 10 days of being aggrieved. There have been no appeals, and they've lost their appeal process. If
With the ZBA,
with the zoning board of appeals.
okay.
There are other processes that are available outside of the county, depending on what the county board does. This is an administrative remedy to get out from underneath the code variation. If that is denied, their ability to appeal to the county zoning board of appeals is lost to them, but there are other avenues available to them.
Okay, thank you. Got it.
Krajewski.
So on this particular one, and I guess all of them, I mean, we issued these licenses to give them the video gaming. And we didn't check to make sure that it was within 1,000 feet or what.
So
Yeah.
prior to 2024, there were no regulations other than the state regulation that says, go get your local liquor license to pour.
So they got the liquor license.
They got the liquor
and then-
license to pour.
Then state put the
The,
county put the 1,000.
when we discovered that there were uses out there that didn't meet the zoning code, we issued violation notices that caused us then to work with various departments in the
But
county
how
board to
did
change the code.
violation, how did the zoning ordinance come into play? It
Uh,
was always there when we issued the license? Or
the zoning,
later?
the zoning code was always there. Liquor licenses aren't reviewed by zoning staff. So when we discovered that there were video gaming facilities out there,
So
that,
when we issued, the county issued them, the 1,000 was in place, we just didn't check that. I
so
understand you said zoning's not involved with the liquor license, but we as a county did,
the 1,000 was not in place since 2019.
okay?
For the gaming.
The gaming was in place. And then the liquor licenses were issued, which allowed them to get gaming. We discovered that they didn't meet the zoning ordinance, and the zoning ordinance was you cannot, have a pour license unless you're a tavern or a Class B restaurant. That's what the zoning code was, and these were not Class B restaurants or taverns.
Well, at some point, the 1,000 was in place and we issued, they got machines.
In 2024, we changed the ordinance, both the liquor code and the zoning code, to put the 1,000-foot distance.
So that's where it
requirement
came in. These establishments all had their gaming.
Prior
We
to
put
that.
them in 2024.
Correct.
And most of the time, don't we, when we rezone certain areas, don't we do a lot of non-conforming? So let's say for development purposes, we'll have non-conforming lots when things are changed. And I mean, we do that a lot.
Understood, yeah.
But in this case, we didn't say you're non-conforming because we changed rules. I mean, it happens all the time where, many years ago, I was mayor of Down Grove. I had so many non-conformings because rules changed after, and I understand, we also do grandfathering.
Right.
We have PUDs for stormwater ordinances. All the PUDs prior to 92 were grandfathered in as long as, the current, they meet the current changes the county made. But don't we do that a majority of the time here in the county where we have them not, when we change rules?
We have non-conforming regulations
Yeah, they're
in the
all over the
code.
place.
The issue here was that these uses were never legal under the zoning code. That's the issue. They were never legal under the zoning code. They're
Okay,
always,
so this is where we issued it, not checking on. All right, so now their only remedy is to get a variance.
correct.
Because, and
I remember when you say we issued it,
we, the county,
the
the county
yeah,
issued
the
it.
county chair is the liquor commissioner, we're not. So there's a difference there.
And yes,
Okay, so the county chair issued these liquor licenses without checking with.
well, the way the process works when liquor licenses come in is that they, prior to 2024, they came into the clerk's office. The clerk's office distributed them to different departments in the county.
Prior to when?
Prior to 2024.
Okay.
So liquor licenses, and this was for all liquor licenses. They would come into the county clerk's office, they'd be distributed to the sheriff's office, the health department, the building department. Those agencies will review and then send their comments back to the clerk. If the clerk got positive results back from all those disciplines, they would send it up to the county liquor control officer. The liquor control officer would sign off on it, and they'd send the certificate for liquor license back to the clerk. The clerk would issue. By state law, the clerk's got to issue liquor licenses. So that's how the process worked. Historically, zoning has never been involved in the review of those liquor licenses. And that's one of the issues here, is that these liquor licenses were being issued, and for the most part, the type of reviews done by the various disciplines on liquor license were the same for all liquor licenses. You're checking to see if there's any building code violations. You're doing background checks, and the health department is checking to see if there's any health violations.
What about a restaurant coming in? Wouldn't you be doing zoning, make sure you got adequate parking or in parking spots for,
Absolutely, but,
so that would be a review of a restaurant coming in to get a liquor license, a new restaurant. Wouldn't they be going to zoning to make sure that they are compliant with the parking, et cetera?
yes, and recall that we had probably about 10 of those from 2019 to 2024, where they came in and wanted to have a restaurant, and they needed certain parking requirements. They couldn't meet those parking requirements, so they asked for variations from the parking requirements. And in all but
Those
one,
came
they
to-
were
But
denied.
those came to zoning, but now some reason they weren't going to zoning.
Well, they came to zoning for land use considerations, not liquor license considerations. But that's the difference. The
Same
liquor
thing, look,
license,
they're asking for a liquor license, it's the same thing, right?
but they were asking to be a restaurant, and in order to go for the liquor license, they had to get the zoning entitlement.
So in
I
24,
Member Rose, actually, she's got a question. We can't
Did-
have
did
one
it change
person
in 24?
dominate. Brian,
2024.
Brian, hold off for a second. I'll give you another minute. Go ahead.
I'm,
I know you got it.
3 of these are in District 4, my district, and 2 of them are in very close proximity to Glenbard South High School. So, as a former school board member, et cetera, former teenage parent, I'm not in favor of this. And I think, most of us, well, some of us were on the board in 2019 and in 2024. So we've been through this ongoing discussion. And so these things evolved, et cetera, but, I don't think it's, to have them follow the zoning, especially in regard to the 1,000 feet for daycare, churches, schools, which we've already gone through. I don't think that that's a hardship to do that. And I understand the loss of business, et cetera, but those, as you said, are not part of our hardship criteria. So, that's my position.
Or could you just go ahead, Jeff, something like that.
No, I'm saying that, so between 2019, 2024 is when all the various people looked at the liquor license. Did it change after 24 now? Is it?
In 2024, we
The
changed.
chair just gives them out now without going to those?
In 2024, we changed the liquor code, we changed the zoning code.
Right, okay, I understand that.
And that's when,
But nothing's changed with the chair sending it out, or the clerk sending it out to all the departments?
yes. Now what happens is that the building and zoning department actually handle all of the applications for liquor and for video gaming. It ultimately, for liquor, goes down to the clerk, because state law requires that the clerk has to actually issue the liquor license. But the building and zoning department is, you're making your applications now for gaming and liquor to the building and zoning department. And in addition to the health department and the liquor control office and the sheriff's office and the building department reviewing the liquor license and the video gaming, zoning is now reviewing.
So had that been put in place in 19, you would have caught that?
Yes.
Okay. Are there any other questions as it relates to item 6B? And just, just to repeat, especially for some of the newer members. This is a recommending body. What we do today is not, members in the audience, is not dispositive of what's going to happen. Ultimately, this goes to the county board to make a decision one way or another regarding this. And a little bit of history, I've been on the board since 2012 and since 2010. There was never an appetite for legalized gambling in DuPage County and until 2019. And it was very difficult to get to that point. So there's been some piecemeal here, admittedly, in getting the zoning and the liquor requirements as well as the gambling. We've tried in 2004 in particular to try to put it all together so it makes some sense. And ultimately we get to where we're at right now. And the 1,000-foot requirement, Paul, correct me if I'm wrong, something magical about 1,000 feet. It's that we're trying to separate the gambling, if you will, from vulnerable populations. If there's something in the interim in that 1,000 feet, which would separate that regardless of the distance, the requirement is met. So it's not the footage per se. And again, our code is 1,000 feet property line to property line. Property line to property line, you could be 50 feet away from a school, but 1,500 feet away from the school from building to building. So that's another issue, which then gives the petitioner or the business owner the opportunity to come before the zoning board of appeals and say, I'd like a variance, I'd like an opportunity to do my business, because in reality, the 1,000 feet really isn't 1,000 feet. Right, even close.
Correct. And to be clear, 1,000 feet is a well-established sort of planning principle. But more importantly, it's something that has been supported in case law by the courts as a reasonable distance to protect a compelling government interest. So, you know, the 1,000 feet is essentially, depending on if you're on the East Coast or the Midwest, it's essentially a city block. But it's the reason that 1,000 foot was chosen is that's well-established law, that's a reasonable government regulation.
And Mr. Chair, in 6B, we talk about the busy intersection that separates, so that would justify what the ZBA did. Where the busy intersection,
It's right next to
Would-
6C. It's
What's that?
literally next door to 6C.
to what?
6C and 6,
Yeah.
6E are next door to each other.
Butterfield, wait, Butterfield and Park,
Oh, that's,
or to Maple and Belmont.
Yeah.
All right, well,
Yeah.
I think we're talking about that. Okay, any other questions, comments regarding this? Okay, so we have a motion to approve item 6B, petition for conditional use variation to allow video gaming within 1,000 feet and within 1,000 feet of an existing gaming cafe. There's a motion in the affirmative. The zoning board of appeals did deny this. So a yes vote here is overturning the zoning board of appeals. A no vote is sustaining the zoning board of appeals vote. Again, understanding that the vote today is merely a recommendation of the county board. Roll call, please.
Member Krajewski,
I
member Ozark,
No,
member Martinez,
No,
member you,
Nay.
Chair Torrentori.
No. The motion fails. Move on to item 6B. I'm going to entertain a motion to approve ECO 2-26, zoning 2543, 711, or a recommendation to deny the zoning board of appeals a variation to allow video gaming terminal established within 1,000 feet of a place of assembly. A variation to allow video gaming terminal established within 1,000 feet of an existing gaming cafe. There's a motion and a second. Any questions, comments on this one, Petruski?
Yeah, there's a third one, Paul, on the southwest corner. Is that coming to it? The Amico station?
Yes, they will have to come to us as well.
Okay. I mean, we have 6C and 6E. One's a yes, one's a no. They're literally right next to each other on the two corners. They're, I mean, one I heard 75 feet to daycare, the other's 80 feet. We allow one, we're not allowing the other. Have you been inside Angelo's?
Yes.
Okay, so it was a grocery store. There's no groceries in there anymore. It's basically just video gaming, and you can probably take to go alcohol. The 7-Eleven is actually still a 7-Eleven with you know, and I read at least the transcripts from the ZBA for the 7-Eleven, which seem to make the good arguments. I just, now I'm having a real hard time. They're pretty much same distance to the church, same distance to the daycare center. We got one for a yes, one for a no, and we're gonna have another one coming is on the other corner. And I don't know, I guess tell them to look at both of these and figure out, I mean, I don't know. So I'm having a hard time really, I mean, you say yes to one, no to another. They're right next to each other, next to the same places.
The ZBA heard these cases on separate nights, and as we know, that each case stands on its own merits. The ZBA found that in the one case for approval, the petitioner approved up the hardship. In the case of 7-Eleven, the ZBA found that they didn't prove up the standards.
And then we got a third one coming. It makes no sense. I mean, it's the same daycare, it's the same church. And actually one is just, the only reason Angela's is still there is because it's video gaming. The groceries are long since gone out of that place. And the 7-Eleven is still a 7-Eleven. And they got a boxed in area there. So.
Let's remember that
Remember what?
there's policy, well, let me finish.
I mean, I'm
I'll
reading
tell
the,
you what to remember.
reading the transcript.
There's these maybe policy decisions which you can deal with, and which we could deal with at the county board level, which is between now and whenever that may be, whether it's next week or whether it's next month, so. But your point's well taken. Okay, so we have a motion and a second to approve the petition on item 6C. Roll call, please.
Member Krajewski,
Aye.
Vice Chair you,
Nay.
Member Martinez,
No.
Member Ozark,
No,
Chair Tornatori.
Aye. And the motion fails. Moving on to item 6D, entertain a motion to approve DCO 3-26 zoning 2544. 7-Eleven zoning board of appeals recommendation to deny conditional use to allow video gaming terminal. V1 business zoning district and variation to allow video gaming terminal establishment with 1,000 feet of school and daycare. Do we have a motion? We have a motion.
So moved.
Second.
second,
Motion second. Any questions, comments on this item? Roll call, please.
Vice Chair you,
Nay.
Member Ozark,
no,
Member Krajewski,
Aye.
Member Martinez,
No.
Chair Tornatori.
Aye, and the motion fails. We got item 6E, I'll entertain a motion to approve DCO 4-26 zoning 2545. Zoning board of appeals recommendation to approve a variation of allow video gaming terminal establishment with 1,000 feet of assembly and daycare, and a variation of allow video gaming terminal establishment with 1,000 feet of an existing video gaming cafe. We have a motion and a second. Or a second.
Okay.
Roll call, please.
Member Krajewski,
Aye.
Vice Chair you,
Aye.
Member Martinez,
The I overturns, right?
This was approved at the zoning board of appeals, so an aye.
So a yes overturns.
No, a yes allows,
Agrees with-
allows,
Yes.
allows what the zoning board of appeals said to stand. This was an approval.
So no.
so, Member Ozark,
I'm a guess on this one.
Yeah, she's here.
Okay,
Member Covert,
we're on item 6E, yes or no?
how did you phrase the question?
The motion to approve. Item 6E.
ZBA approved it.
UVA approved it.
I'm voting no, no.
I know. What about me?
Oh, Chair Tornatori.
Aye. Okay. So that motion is approved. Moving on to item 6F, I'll entertain a motion to approve DCO 5-26 zoning 2546. Penny's Place recommendation of the zoning board of appeals to deny conditional use to allow video gaming cafe in a B1 local business districts, variation to allow video gaming cafe within 1,000 feet of a place of assembly, and a variation to allow video gaming terminal establishment within 1,000 feet of an existing video gaming cafe. Do we have a motion?
So moved.
Or a second?
Second.
I'm gonna ask council for a question here. It's my understanding that the party that was representing, I don't know if the person's an attorney or not, Penny's Place, suggested that there may be some additional information that they would have placed forward but didn't because they didn't know. That being the case, I know this is a little bit far from what we've ever done. I'll offer the opportunity, I think we can do that, to the petitioner if they wish to withdraw, refile, present their case in a different way. They give them that opportunity and we can, you can either pull this from the file, pull this from the agenda today.
Mr. Chairman, I would be happy to withdraw or reapply, whatever is the best, knowing that.
We can pull it from today's agenda and then you can determine which way is best with all of the zoning people.
Okay. And as a matter of process, I just want you to know, because in the wild or in real life, we did have a zoning inspection.
I know, you built your building, yours is a little bit different from the others. It wasn't.
June of 2025 after.
I can't take other.
I just want to make sure that
But you're withdrawing it, so,
Yes, please.
okay, so then we're just gonna pull it, so. There's no motion or second, that's.
No, because we're not tabling it.
We're pulling it, all right. Okay, that takes care of 6F. 6G. I'll entertain a motion to approve DCO 6-26 zoning 2548, Lucky 7 Bistro. Board of Appeals recommendation to approve variation to allow video gaming cafe with 1,000 feet of existing video gaming cafe gaming terminal establishment. There's a motion and a second. Any questions, comments on this? Roll call, please.
Member Krajewski.
Aye.
Vice Chair Yu. Aye. Member Martinez.
No.
Member Colbert.
No.
Member Ozark.
Aye.
Chair Tornatori.
Aye, and the motion passes. These items will presumably, with the exception of item 6F, be on next week's county board meeting. Those of you who are here, I appreciate you being here, sitting through this. It's a process, and we brought up at the next county board meeting. Is there any old business?
Sorry.
Yes.
I just wanted to thank you, Chair, for excusing me for my other,
Totally.
allowing me to rejoin.
You are, I don't know if it's what I allow you to do, but you're welcome. You're always welcome.
You are,
Thank you, thank
you are
you.
entitled.
And you're entitled. Any new business?
Well, I'm just gonna add something to that, just about like our
Sure.
discussion today and in general that, I just want to let people know that we are in hard times right now and with gaming facilities, there's a lot of people that lose their money to gaming facilities and machines and that ends up, in poverty and, with hard times right now, I know villages and cities get a lot of money from gaming facilities, but at the end, if people don't have money in their pockets, then that really doesn't help a village or a city. So that's all I wanted to say. Okay, thank you.
There being no old business or new business, I'll entertain a motion to adjourn.
So move.
Second.
All in favor?
Aye.
We are adjourned.